Please be seated. We're ready for argument in 2348, Ford Motor Company against Parks.
May it please the court, Mr. Minucci will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The justification for any statute of repose is a time gap. The defendant's entitled to absolute freedom from litigation after a legislatively determined period of time. The product liability statute of repose provides a 15-year time gap. It must have been at least 15 years between the date of sale of the product and the filing of suit. The plain language of that statute reveals two routes to prove entitlement to repose. What I'll call route number one is to prove an exact date of sale. If it's more than 15 years before the suit is filed, you're entitled to repose. What I'll call route number two is to prove that the date of sale, whatever it was, had to have been more than 15 years before suit. Both routes satisfy the necessary time gap, and Ford conclusively proved its entitlement to repose under both routes. The Court of Appeals here made two errors requiring reversal. First of all, the court elevated route number one from sufficient to prove repose to necessary to prove repose, thereby eliminating the availability of route number two to product manufacturers. The second error that the Court of Appeals made was on route number one, the exact date of sale. The Court of Appeals made the evidentiary burden so impossibly high that very few product manufacturers will be able to prove an exact date of sale and avoid litigation. The upshot of this is that the Court of Appeals decision deprives repose from a large number of product manufacturers the statute of repose was designed to protect.
So what's the test about when a sale occurs? Is it basically just the UCC?
It is. I think all parties accept, and the Court of Appeals accepted, that it's the Camacho test. Very simple.
Well, I mean, we can call it the Camacho test, but
sure.
We passed the UCC in this state, and so it's really the UCC test, the transfer of title for a price, right?
It is. It's exactly what it is.
This is a sale of goods, I take it. It's not this would be governed by the UCC.
Correct.
So why don't we just look at the UCC and see if there was a transfer of title for a price?
That's exactly what we did, and Ford proved that with overwhelming and conclusive evidence, and I'll get to that and what that evidence was in a minute.
And under the UCC, you don't have to have a price paid at the time the title is transferred. Is that right?
That's correct, and that's the point that the U.S. Chamber of Commerce made in its amicus brief. You don't have to prove payment at the exact time the title is transferred. So the examples they use in their brief include a sale on credit, for example, or an installment sale.
Well, and that's what Section 2.401 of the Business and Commerce Code says, right, about the passing of title regardless of whether there's a lien that's retained.
Correct. Let me discuss what I called the first error that the Court of Appeals made, and that was completely ignoring and failing to acknowledge Ford's conclusive evidence that the date of sale, whatever it was, had to have been more than 15 years before Parks filed suit. This error is important because it cuts off repose from every manufacturer of an old product that can't prove an exact date of sale and the exact date that it was paid for the product due to lost or destroyed records, lack of witnesses, or faded memories. And we know that loss of that kind of information is precisely what repose is designed to protect a defendant against. By ignoring route number two, the Court of Appeals makes it harder to invoke repose the older the product, which sort of turns the statute of repose on its head. As an example, if you could imagine that this accident involved a 1920 Ford Model T that was purchased from a Ford dealer nearly 100 years ago. Will the exact date of sale of that product be known? Probably not. Will a receipt showing the exact date of payment exist? Almost certainly not. But should Ford be entitled to repose on that product? The answer is clearly yes. Under the Court of Appeals analysis, however, Ford would be out of luck because it wouldn't be able to produce that actual receipt of payment on a date certain. Ford would have to litigate the issue of repose, but not only litigate that issue, but also defend the product itself and the defect claims against the product in court without any records to support that defense either. Federal courts that have applied the Texas Products Liability Statute of Repose seem to have this concept right. They have held fairly uniformly that repose applies where a manufacturer had to have sold the product at some point more than 15 years before suit was filed, regardless of the exact date of sale. Ford cited a couple cases in its brief on this point. The first one, Burdett versus Remington Arms, 5th Circuit, 2017. In that case, a consumer purchased a rifle from a retailer in 1998, and the court didn't worry about an exact date of sale of that rifle. The court simply said, quote, "The date of the rifle's first sale was undoubtedly prior to 1998, and that was enough to satisfy the statute." Another federal case cited by Ford in its brief, Scarborough versus Bristol Myers Squibb, an Eastern District of Texas case from 2008. That case involved breast implants, and the manufacturer of breast implants didn't prove an exact date of sale of those implants, but only proved that the plaintiff received those implants more than 15 years before she filed suit. So the federal courts have adopted this concept that the Court of Appeals here did not. I mentioned a second error that the Court of Appeals made, and that was on route number 1, and that's the exact date of sale route. On this route, the Court of Appeals made the evidentiary burden far too high, essentially requiring production of an ancient receipt showing payment from the dealer to Ford on a date certain to prove the date of sale. And like the first error that the Court of Appeals made, this deprives numerous product manufacturers of the benefits of repose. If you can't produce an ancient receipt showing when you were paid, there's no repose because you haven't proved the date of sale. That can't be right. Let me discuss the evidence that Ford provided, conclusive evidence on route number 2, and this is the concept that Ford had to have sold the vehicle more than 15 years before suit was filed. Again, the Court of Appeals completely ignored this argument and this route of proving repose in its analysis. We know that the plaintiffs filed suit in May 2016, so Ford would be entitled to repose if it sold the vehicle before May 2001. Ford's witnesses, Mr. Pasquarella and Mr. O'Brien, testified that Ford sells vehicles to dealers who then sell to customers, and in fact, Texas law mandates this arrangement. Ford cannot directly sell to retail customers in the state of Texas by statute. It has to go through a dealer. Then, the evidence showed that the first consumer who had the vehicle, Mr. Charles Stewart, acquired the vehicle from Ford dealer Town East Ford in June of 2000, and that comes from plaintiff's own evidence.
By lease?
By lease.
Okay.
By lease.
And the lease says, should have looked at the lease and didn't, but the counterparty for the lease is the dealership.
Correct.
Okay.
Correct. He filed an affidavit, and I have it here if we need to look at it further, but he said, "I leased the vehicle from Town East Ford," were his words.
So it's not like Ford Motor Credit or some other it's the dealership.
Correct. That's what he testified to. So that's our second piece of evidence. He acquired it, transacted it from the dealer, June of 2000. That's plaintiff's evidence. And then another fact from plaintiff's evidence that's conclusive here is that the vehicle was actually titled to Mr. Stewart in July 2000. Again, that's plaintiff's own evidence. So he's the owner at that point. What that inexorably leads to is the conclusion that Ford had to have sold this vehicle at some point, pick your date, before it was titled in Charles Stewart's name in July 2000, a full 15 years and 10 months before suit was filed. Now, how do we know Ford got paid for this vehicle? Well, there's two reasons. First of all, we have the testimony of Mr. Pasquarella and Mr. O'Brien. They testified to the entirely unsurprising fact that Ford gets paid for its vehicles by dealers. It doesn't give them away. These products are worth tens of thousands of dollars, and Ford is not in the business of giving those away to dealers. Secondly, we have a contract, the Vehicle Terms of Sale Bulletin. And that contract very clearly states, unequivocally, that the dealer pays Ford for each vehicle on delivery of the vehicle to the dealer or to the carrier, whichever occurs first. So we have the testimony of Pasquarello and O'Brien about Ford's business practices, and we have the contract between the parties. That's how we know Ford got paid for this vehicle, even though we don't have an actual receipt of payment. in
Does
this
it
case.
matter whether Ford got paid for the vehicle? I mean, doesn't Camacho tell us that whether payment was made is a different inquiry about whether there was a sale?
Does it matter if Ford was paid for the vehicle?
Yeah.
Well, if the Camacho definition is transfer of title for a price, you could argue that it does, but I see your point. It actually doesn't. It's as the U.S. Chamber of Commerce points out in its amicus brief, it's sort of a concept of consideration, right? Ford transfers the title, and payment may or may not be received at that time, or may never be received, but the promise, the consideration of payment, is what clinches it as a sale. But in this case,
say if Ford, if the dealer, for example, didn't pay, presumably Ford would have a breach of contract claim against the dealer, but that doesn't mean that there wasn't a sale. Is that?
That's right. And, you know, if that's one of the arguments that Parks makes here is speculation that, well, maybe the dealer never paid Ford for this vehicle, or maybe Ford gave the vehicle to the dealer. Under these same contracts I've been mentioning, Ford had a security interest in a vehicle and a right to repossess if it doesn't get paid. So why wouldn't Ford have done that if Ford didn't get paid for this vehicle? It's just another fact that leads to no genuine issue of material fact that Ford's entitled to repose.
Well, and Business and Commerce Code 2.401 says you focus on whether the seller performs, for example, by delivery despite the reservation of a security interest.
Correct.
So the reservation of a security interest, that seems to suggest would satisfy the price element, whether money later changes hands or not.
I think that's exactly right.
So do we know whether a security interest was reserved in this case?
I believe under the contracts involved, the vehicle terms of sale bulletin, there is a security interest that Ford has in a vehicle until it receives the price thereof.
Okay.
Let me discuss in the limited time I have left here Ford's evidence on route number one, because as I mentioned, Ford not only provided conclusive evidence entitling it to repose under route number two, but also the exact date of sale, route number one. Again, Ford didn't have an actual receipt of sale, an actual receipt of payment for this vehicle, but Ford had everything else you could have here. A business record, the Mini 999, which states a release date of May 9th, 2000. Then Ford had overlapping testimony from two witnesses, Pasquarello and O'Brien, longtime Ford employees with knowledge of Ford's business practices and what the Mini 99 meant. And they testified that the dealer is obligated to pay Ford when the vehicle is released on the release date. That is Ford's business practice, and that's what the date on the Mini 999 means. Mr. Pasquarello testified in his Camacho deposition something that I think gets right to the heart of this. He said, it's like Amazon. They don't ship it before you pay for it. That's the same thing with vehicles. Ford's not shipping a vehicle to a dealer until there is payment for it or a promise to pay from the dealer. Third, Ford had contracts between itself and the dealer, and I just mentioned these contracts, the sales and service agreement and the vehicle terms of sale bulletin. And in no uncertain terms, that requires the dealer to pay Ford for each vehicle when it's delivered to the carrier or delivered to the dealer, whichever one comes first. So Ford shifted the burden at that point to the plaintiffs on this issue of date of sale. And the plaintiffs countered with speculation only. They said, well, maybe Ford consigned the vehicle to the dealer. That's complete speculation on this record. There's no evidence of it. And again, in a consignment arrangement, Ford would still own the vehicle, and Ford could not have transacted that vehicle to Mr. Stewart, so there was no consignment here. Parks says, well, maybe the dealer never paid Ford. Maybe Ford gave the vehicle to the dealer. I've discussed that already. There's no evidence of that. It's speculation under this record. It goes against the undisputed witness testimony of O'Brien and Pasquarello, and also, again, brings up the fact that Ford didn't exercise any sort of security interest. See, my time's about up. If there are no other questions,
Any other
Sit down.
questions? Thank you, Mr. Minucci. We'll hear from the respondent.
May it please the court, Mr. Levenger will present argument for respondents.
Mr. Chief Justice, may it please the court, I want to start with what Ford told the Court of Appeals in its appellee's brief, because it framed the issue for decision very differently from what it's now saying, and it framed it in a way actually that supports what we're saying. Here's what it said on page 14 of its appellee's brief. This court's simple job is to examine the affidavit and deposition testimony of O'Brien and Pascarella and decide whether it meets the interested witness criteria set forth in Rule 166AC. If the testimony meets that standard, the summary judgment should stand. If the testimony does not meet that standard, the summary judgment should be reversed. And it really is that simple. And it underscores the fact that this case doesn't turn on the interpretation of Section 16012. It doesn't threaten the viability of the repose statute. It simply turns on the fact that Ford did not meet its summary judgment burden of conclusively establishing every element of its repose defense.
So
And-
why doesn't sale turn on what the UCC says?
I think we've all converged on the definition of sale under the UCC,
Okay,
a
so it
passing of
doesn't
title from the seller to the buyer for a price. We've all
Right, but
agreed
it
with that.
doesn't seem to require that that price be paid in order for title to transfer.
Well, I agree with that in a general sense, in a general proposition. The problem is, in this case, and I'm jumping a little bit ahead because my initial contention is there's a fact issue as to whether a sale even took place in the first place. The evidence is not clear and conclusive as to
The
whether a
title
sale.
transferred.
But I do want to answer your question about the date. And here's the problem. As a general proposition, the price does not have to be paid commensurately with the sale, with the transfer. But in this case, Ford took the position, they added a wrinkle to that. They said over and over again that the price is always paid in full by the dealer to the seller on the release date. They said that in Mr. O'Brien's affidavit at paragraph 6. He said it again in his deposition at Camacho, and he doubled down on it again in his deposition in the Parks case.
And you don't have any evidence to the contrary?
We don't know when the price, they say the price is always paid, every transaction, on the release date.
So
We
why
don't know
isn't
that.
that some evidence that it was in this case?
Well, the problem is that testimony that the price is always paid in full on the release date, it's inconsistent with their own documents, okay? And the documents I'm referring to are the sales and service agreement, which says that Ford gets a security interest until it's paid, which indicates that price can be paid later by the
Right,
dealer.
but a security interest is as good as paid for the UCC purpose.
It may well be, but it's inconsistent with the position that they took consistently that they had to pick a specific date, that the price was always paid on the release date. And they had to take that position in order to sort of transmute the term release, which they define very differently.
I don't understand why they're doing that, changes the definition of what we're talking about.
The problem began, Justice Lerman, with their very first motion for summary judgment, in which they claimed that the first and only sale was from the dealer to the consumer, to the customer. They did not argue that the transaction from Ford to the dealer was a sale. In fact, they called it a release, and they defined that as the vehicle leaving our possession, custody, and control. That's not a sale. Leaving possession, custody, and control is a consignment.
So you're making some kind of a waiver argument?
Well, it's not so much waiver as it is their first motion for summary judgment started creating the set of inconsistencies and contradictions that rippled throughout this case, and everything they did thereafter with
But
O'Brien's
if-
affidavit was an effort to sort of,
If we grant you that there's an inconsistency, doesn't the inconsistency have to be material? Doesn't have to matter? I mean, if you give me a ticket for running a red light, and all the evidence proves that the light was either green or yellow, either way, I beat the ticket, right? So
But-
here, either they got paid before, or they had a promise to pay, because they wouldn't release without at least the security interest. But either the payment or the security interest is green or yellow.
well,
It's not red.
they made it material. They made it material. They made the specific date material. They said the purchase price is always paid in full on the release date. Let me read you page 28 of their Court of Appeals brief where they said it. If Pascarella or anyone had testified that Ford exchanges its vehicles with a dealer for a price on some day other than the release date, then Ford never would have moved for summary judgment. There would have been a genuine issue on the one material fact that matters here. They said that.
Well, the
Not
one
me,
material-
they said
but
that.
why isn't the one material fact that matters whether the sale occurred more than 15 years before the suit was filed?
Well, because we don't know on this record how payment was made, when it was paid, or even whether payment was
But
made. That's-
isn't that just a matter of whether Ford has a breach of contract claim against the dealer? Because we do know, don't we, from the lease, that the owner was the dealership on the lease date, according to the lease document.
Well, we know that the dealer had the vehicle because it entered into the lease with the customer. We don't know
But
how
to lease
the,
it, to lease it to somebody, you have to own it, right?
no, not necessarily, not necessarily.
So you think the lease wasn't any good?
Well, I don't know on this record. I know that they
But is
defined.
there any evidence of that the dealer didn't own it on the lease date as is being represented in the lease document?
There's just no evidence one way or the other.
Well, isn't
And
the lease document some evidence that they owned it if they're purporting to lease it, the dealer?
it's some, but it's inconsistent with Ford's definition of release, okay? They used the term release and they used the term sale in the same affidavit, Mr. Pascarella's affidavit. They used sale to describe the transaction between the dealer and the customer. That doesn't count for repose purposes. They used release very differently. They define it as letting go of possession, custody, and control. And that creates a fact issue, an inconsistency, as to whether there was a consignment.
Doesn't the contract equate those two things? Because it says that the transfer of title occurs when they relinquish possession, custody, or control to the person that, I can't remember the term, but the person that's basically shipping it to the dealer.
Well, title's another issue. They admitted that they don't have title. They transformed it and said, well, we're using the word ownership. And they said ownership transfers, again, they're pinning it to the date of release. And yet the evidence is inconsistent about that because Pascarella said, well, ownership transfers only when we're paid in full. Again, and yet there's a fact issue as to whether that occurred on the date of release, which is what they chose. Because, again, their own documents show that the payment can be and frequently is made long after the date of release. All I'm saying is they created their own set of inconsistencies, starting with their initial position in this case, that the first and only sale is from the dealer to the customer. And they pivoted when they realized that that doesn't work under the repose statute. The only sale that counts is from the manufacturer. And yet they were left to scramble because they had not defined that as a sale. They called it a release. And a release is simply, as they said, letting go of possession, custody, and control.
They retained a security interest.
They're entitled to take a security interest under the sales and security agreement that says Ford can get a security interest until paid, indicating that payment, contrary to what O'Brien was saying, payment can be made long after the release date.
That's pretty common in the buying of cars at the consumer level, isn't it? I mean, there's always a secured interest that's retained until it's paid in full, which might be years later, but you've certainly bought the car. It's been sold to you long before that happens.
That's a reality of a transaction between, I think, the dealer and the customer. But as you indicate, payment is paid in full many years later. And yet they're saying ownership transfers, title transfers, only when we're paid in full. So again, we don't know when that happens on this record.
Do you agree that the record conclusively, there's no opposing evidence against the evidence that, is it Mr. Stewart, Charles Stewart, the first owner? I forget his name.
Stewart.
That Mr. Stewart obtained title of the vehicle by July 2000?
He obtained title, I believe, by July of 2000.
So you don't dispute that?
No.
You just dispute that Ford got paid for that title?
Well, we don't know.
You dispute that the record is sufficient to establish that Ford got either paid or promised to pay for that title?
They did not conclusively prove two things. The fact that Mr. Stewart had title tells us nothing about how Ford got the vehicle to the dealer. The record is inconsistent as to whether it got there via a consignment, a bailment, or a sale. We don't know that. Then the record is equally inconclusive about when the dealer paid Ford. They take the position, Mr. O'Brien did, in every transaction, always, the dealer pays in full on the release date.
But
And yet we know that's not true.
How is that material? How is it material when the payment happens?
Well, in a general sense, it wouldn't have to be, but Ford made it material. Ford made it material by taking the position that payment in full is always made on the release date. And they
Okay,
did
but-
that in order to somehow transmute release, which they defined very differently, into a sale. That was the position they were forced to take. And as I say, on page 28, they said at the Court of Appeals, if someone had testified that the price was paid on some day other than the release date, then we would never move for summary judgment. That's a material fact question. So they made it a material fact question. GM, Chrysler, in a repose case, it may not be a similar issue because they have better records. My point is if Ford wants to rely on the repose defense, which has been around since probably 1993, they need to have records that are clear and consistent.
So you
And they
think
don't.
that there's a fact issue about whether Ford still owned the vehicle when it was titled, after it was titled to the lessee?
I think their own evidence creates that fact issue, right? Because take, for example, their vehicle information report and their Mini 999. Those are two of their documents.
But can that happen under state law that if somebody gets, if only a dealer can sell something
Right.
to, or lease something to a customer, and the customer actually gets a title from the state as the lessee, is it even possible as a matter of state law that Ford would still have an ownership interest?
It is possible
How is
because,
that?
well, because Ford would not be making the sale. The only prohibition in the statute, and it's the occupations code, they call it the transportation code, but it's the occupations code. The only prohibition is that only an authorized dealer can make a sale. In other words, a manufacturer like Ford cannot make a sale. Under the consignment possibility that they themselves have set up by using the word release to mean transferring possession, custody, and control, a consignment doesn't violate that statute in any way because the dealer is still making the sale, not Ford. The dealer's making the sale. Under a consignment, Ford retains ownership, and upon the point in time when the dealer sells it to the customer, Ford transfers the title to the dealer. Ford transfers title to the customer. That does not violate the statute because Ford's not making the sale, it's
But
just transferring
even
the
if
title.
that's what happened, it was consigned by
Right.
Ford to the dealer and then sold to the customer.
Right.
And then Ford transferred title to the customer. You concede that had to happen by July of 2000.
Yes, but it's not a sale. And the only thing that triggers repose is a
It's not a
sale by the
because there
defendant.
was no price?
Because it was a lease.
Well, that was the problem they got themselves into in the connection with the first motion for summary judgment. They were relying on the transaction between the dealer and the customer and saying that's a sale. And it turned out it was not a sale, it was a lease. A motion for new trial was filed. Ford essentially agreed to the motion for new trial, saying, yeah, we got it wrong, it wasn't really a sale, it was a lease. But we're going to move again because now we're going to focus on the right transaction under the statute, the transaction between the manufacturer and the dealer, the defendant and the dealer. The problem was that's where they started creating the inconsistencies because they were saddled with their own definition early on in the case that the only transaction between the manufacturer and the dealer is a release, letting go of possession, custody, and control. That's not a sale. Their vehicle information report showed only one sale from the dealer to the customer, not from the manufacturer to the dealer. Their Mini 999 report shows only one sale, again, from the dealer to the customer, not from Ford to the dealer. So all I'm saying is that
I'm showing my ignorance here, but why would you get a title if you're just the lessee?
I'm a little bit ignorant about that too, Justice Busby, but I think under the Certificate of Title Act, the whether you acquire a vehicle by lease or by purchase, you get a title. I mean, I lease my vehicle and I have a title. I can assure you that. So, but we're not relying upon the Certificate of Title Act. That was our position at one time. That's not what we're relying upon, because the focus necessarily under the repose statute is between the defendant, in this case the manufacturer, and the dealer. And that's where we have fact issues as to, one, whether there was a sale at all, and two, if there was a sale, when the payment was made. And they're the ones who make the payment essential. As I say, they're the ones that have gone on record as saying it's a material fact issue as to when payment was made. Was it made on the release date? It's critical to them, according to Mr. O'Brien, that price was paid on the release date. In another transaction, in another repose case, it may not be critical, but they made it critical, they made it material, and there's a fact issue on that point.
You haven't mentioned the issue of whether the manufacturer has to prove a date specific as opposed to merely prove that the sale occurred at some date more than 15 years earlier. Do you concede that the latter is sufficient?
In an ordinary case, and as a general proposition, I would say that the manufacturer does not have to prove a specific date by which it got paid. In other words, we know you can have credit sales, you can have installment sales, you can have layaway sales. So you don't have to prove a specific date, so long as you can prove that the passing of title for a price occurred more than 15 years before the suit was filed. The problem in this case, again, this is a one-off case. They made it material that the price was paid in full on the release date. If you look at my handout, you'll see footnote 6. That's where we cite to Mr. O'Brien's testimony in 3 different places where he's saying the purchase price is always paid by the dealer to Ford on the release date, period, unequivocally. He says that. And he does it in order to avoid the problem they created for themselves when they defined a release very differently from a sale. The problem is it's inconsistent with their own documents. Their own documents indicate that the price is not always paid on the release date. And on this record, we don't know how the price is paid, when the price was paid, or even whether it was paid. And that's why we're not saying they may not be able to get repose at some point. We're not saying the repose defense is unavailable. We're simply saying they need to prove it to a jury at this point. They did not conclusively establish each and every element of their repose defense. And repose is no different from any other affirmative defense. You need to conclusively prove it. They talked about how repose relieves them from the problem of absent evidence. I suggest to you that doesn't apply to establishing your repose defense in the first place. You need the documents or the consistent testimony to prove your repose defense. And in this case, that would be something other than their VIR or their Mini 999 that do not show a sale at all from the manufacturer to the dealer. I'm sure somebody like GM or Chrysler would have better, clearer, consistent documents, but Ford lacks those documents, and as a result, they create internal inconsistencies when they take the position that only a release occurs, and a release being the turning over of possession, custody, and control. They get in trouble when that's inconsistent with their own documents. They get in trouble when they tell the Court of Appeals that we never would have moved for summary judgment if somebody had said the price passed on some date other than the release. Well, the documents show the price passed on some date other than the release. So they should not have moved for summary judgment. They should prove it at trial. They may well be able to do that, but it comes down to whether they can prove it by a preponderance of the evidence. And the simple issue here is, did they conclusively establish it through their interested witness testimony, which gives rise to the requirement that it be clear, unequivocal, credible, and free from contradictions and inconsistencies. And on that limited issue, the one they posed at the beginning of this case, they cannot meet that test. They cannot meet the interested witness test because the testimony that they relied upon is not free of inconsistencies and contradictions. It's full of them. all of which started at the beginning of this case. I think that concludes all I have to say. I think the brief adequately explains why Camacho doesn't necessarily dictate the result of this case. You have different procedural rules. They don't have the interested witness requirement, different procedural posture in that case, and different facts. We don't know anything about the comparison between the two dealers. We don't know that the two dealers in Camacho in this case had the same arrangements with Ford with respect to when and how it got the vehicle and how it paid for it. So I don't think Camacho will assist you in resolving this case.
Any other questions? Thank you, Mr. Levenger. Mr. Minucci, you have 5 minutes. Excuse me.
The bulk of Park's argument just now is all about inconsistencies in Ford's evidence, or alleged inconsistencies, I should say. So let me take a minute to explain where those came about and how they came about. And that starts with the principle that as a litigant, you tailor your summary judgment motion and evidence to the law and the allegations at the time you file. So let's go back 6 years ago to 2018, when Ford first filed for summary judgment on repose in this case, and that's the time when Mr. Pasquarella's first affidavit was executed and filed. Now, at that time, the law was pre-Camacho, so it was unknown under this statute whether the trigger date was the Ford to dealer sale, the wholesale, or the dealer to consumer sale. And there are some states where their statute of repose is it's consumer-centric. It's triggered by a consumer sale. So at that time, in Ford's motion, stating a date for a dealer to consumer sale covers either eventuality, because the Ford to dealer sale always precedes that. No one has ever questioned that that happens. So Parks didn't have any problem with Pasquarella's first affidavit. They didn't even file a response to Ford's initial motion for summary judgment, and it was granted. They had no problem with the evidence at that time, but then the plaintiffs changed the game. Parks changed the game. First, they came back and alleged that the trigger date wasn't either of those two sales, but rather something called the first sale under a different statute, the Certificate of Title Act. Then they came up with this evidence that the first consumer leased the vehicle from the dealer. As an aside, we think that's wrong, but whatever. And then they also came up with the argument that Ford never sold the vehicle at all, which certainly we'd never seen before in a repose case, pretty novel. So new allegations and new evidence from the other side prompted a new motion for summary judgment with additional, and I emphasize that word additional, not contradictory evidence in support. So at that point, Ford had to refine its legal arguments and actually make the argument about which sale triggered repose out of the wholesale or the dealer to consumer sale. And Ford argued that the Ford sale to the dealer was the one, and that was eventually affirmed by the Camacho court. Ford also had to provide evidence at that time that Ford's transaction with the dealer here was indeed a sale, because again, plaintiffs brought up after the fact that Ford had never sold this vehicle at all. If you look at Mr. Pasquarella's second affidavit, he very clearly talks about this, and he says, based on the information submitted by plaintiffs in their motion for new trial, I am supplementing my earlier affidavit. So he's adding facts. He's not contradicting himself. And then he also says in his second affidavit, my original affidavit was accurate. So Pasquarella's first affidavit, he says, the date of release is the date that is on or near when the vehicle leaves Ford possession, custody, and control. That's accurate. One of the things that happens in a sale is a transfer of title. And that's what he's describing here. In his second affidavit, it's not contradictory. He adds the additional fact, because it's now relevant based on plaintiff's allegations and evidence, that it's also a sale. It's the time when Ford is to receive money from the dealer. So this whole notion that their entire defense is based on, that there are inconsistencies here, is not correct. That's why Ford attached all the evidence in the appendix to its brief, and Parks attached none. Because when they talk about inconsistencies, it is, respectfully, it's spin. It's not supported by evidence. We know what these contracts mean because we have testimony from Ford's witnesses that is consistent and the same. So there really aren't any inconsistencies here. As an example, in Park's brief and also in this handout, and up here I just heard, there's the allegation that Ford initially said the first and only sale was to the dealer. Not true. If you look at this record, there is nowhere where Ford says the only sale of this vehicle is to the dealer. It's not in the record. It's not in any of the evidence that is in the appendices. Unless there are any further questions, that's all I have.
Any other questions? Thank you, Mr. Minucci.
Thank you.
The case is submitted, and the court will take another brief recess.
Thank you.